As I said, good afternoon, everyone. My name is Tim Richards. I'm the Technical Services Manager of the Managing General Agents Association. And on behalf of the MGAA, I'd like to welcome you to our briefing this afternoon. This is being delivered by Clyde & Co. on the subject of the GDPR and the ICO. Before I introduce our presenters, I'd just like to run through a few housekeeping points. Please ensure your microphone and camera are turned off. If you'd like to ask a question, feel free to use the chat button at the bottom of your screen. Time allowing, these will be asked of the presenters at the end of the event. So that will probably be about after 45 minutes or so. If we run out of time, questions will be answered post-event, and this presentation is being accredited for CPD points if relevant to your ongoing professional development programme. The briefing is being recorded, and a link to the recording will be issued post-event, together with the slides and our feedback survey. Please take the time to complete our survey, which will take no longer than 2 minutes. This allows us to deliver the best possible future events to our membership. So today's briefing is on the subject of the GDPR and the ICO from Clyde & Co. So let me introduce you to our presenters, Helen Bourne and Rosanna Armin. Helen has led the development of the Clyde & Co cyber practice in the UK since 2014 and has been instrumental in developing the firm's global cyber practice. Helen has over 25 years of litigation experience and advises both insurers and corporate entities on a wide range of cyber risk and data protection matters, including incident response. She works closely with the global team on cross-jurisdictional incidents and has significant experience dealing with data protection regulators, including coordinating EU-wide regulatory investigations. Helen has advised on ICO enforcement matters, assisted clients with appeals against regulatory penalties, both in the UK and internationally in the EU. Helen is a regular speaker at industry events, providing insight and commentary on cyber risk and its legal implications. Rose has commercial experience advising insurers on complex cyber risks, data protection and privacy issues. She has extensive experience in cybersecurity, data protection and breach incident response matters. She has advised a large number of clients and provided strategic guidance to senior management of both UK and multinational companies following a cyber incident on loss mitigation due to business interruption, legal and regulatory compliance to financial and data protection regulators in multiple jurisdictions, dealing with governmental and criminal authorities, and addressing queries involving high-profile clients or from consumers following a breach incident. For insurer clients, Rose advises on coverage issues under cyber and tech E&O policies, including on novel and topical issues affecting the market. She also has experience and expertise in advising clients on their cyber policy wordings to deliver a market-leading product for insurers. So, without further ado, enjoy the briefing, everyone, and over to you, Helen.
Thank you very much, and thank you for that very detailed introduction. I'm sure you've all heard more than you needed to know about both Rose and I, but good afternoon, everyone. Welcome to the webinar. We are delighted to be with you today. As you've already been told, we are going to be providing an overview of the data protection regulatory landscape, both in the UK and the EU today. It's quite a packed agenda, so we'll try and get through it, and if there are any questions, we'd be delighted to try and take them either during the presentation if we can, but if you could hold some of the questions until the end, I think hopefully we'll have time to deal with all of those at the end. In particular, in terms of the detail of the webinar, we're going to be highlighting some of the key areas of focus from the UK data protection regulator. We're going to be looking at some of the enforcement action that we've seen in recent months, and before really touching on how you as insurers can mitigate cyber risks and help assist insureds with doing so in terms of managing loss exposures through an effective incident protocol. We're going to be sharing with you some of the stories of how we handle incidents, and hopefully that insight will be useful to you all. So without further ado, I will ask Rose to lead off Rose, can I hand over to you to talk about the GDPR developments?
Thanks, Helen. Good afternoon, everyone. I'll be speaking to you today about the GDPR developments, including the UK and EU perspective. Next slide, please, Gareth. So I wanted to start off today with first focusing from an EU perspective before moving on to the UK perspective. As you know, with Brexit, the UK GDPR and the EU GDPR are now two distinctive pieces of legislation. Substantively, both the UK and the EU GDPR are similar, but it's important to see how, from a regulatory perspective, the enforcement of fines have been quite different. From an EU perspective, we've seen this year Ireland issuing the DPC imposing a fine of 390 million euros against Meta, essentially Facebook. The DPC announced this in January. So just to carry on, the Irish DPC announced this fine. It's incredibly significant and involves a two-part fine, 210 million euros for breaches relating to Facebook and 180 million euros in relation to Instagram services that Meta provides. And the DPC has also ordered Meta in Ireland to bring its data processing operations into compliance within 3 months. So it's not just a monetary penalty, but also an enforcement action taken against Meta. The main complaints against Meta with this 390 million euro fine is the fact that users are now being asked to click I accept to indicate the acceptance of the new terms. Complaints were made that that individuals were being forced as a user to consent to the processing of their personal data to be used for advertising and other personalized services. What is significant about this fine is that the Irish DPC didn't just issue it of its own accord. It actually consulted with other EU regulators, which we've seen regulators do. So what they do is consult with other EU data protection authorities, get their views, and confer with them to issue a fine on the organization, in this case, Meta. Meta was found that it could not rely on this contract when individuals clicked I accept as a basis for targeting behavioral advertising and processing users' data. It's significant that such a large fine was issued, not least because just a year ago in 2022, the Irish DPC also issued a fine against Meta totaling 265 million euros for its failure to implement appropriate technical and organizational measures. And so whether it's the manner in which Meta processed data of its users or its failure to ensure that its systems adopted the technical and organization measures so it was robust from a cybersecurity perspective, we've seen how the Irish DPC have now issued fines well in excess of 650 million euros in just 18 months. Earlier to that, in 2021, we also saw the Luxembourg regulator issuing Amazon a fine of 746 million euros because they failed to comply with general data processing principles. A common theme across all these three very large fines is, firstly, they've been issued against your big tech players, the likes of Amazon and Facebook, and all these fines relate to a failure to comply with their GDPR obligations. It's not necessarily a cyber ransomware attack that they experience, but a compliance issue. And these organizations are also known to process large volumes of data. So it's not surprising that given the scale of the organization, the volume of data being processed, and the failure to comply with GDPR obligations, that such large fines have been issued. So what does this look like? These fines look like against the landscape of fines in total across the EU. It's striking from a numbers perspective that in 2020, the total amount and value of GDPR fines was around 170 million euros. And in 2021, the following year, it was 1.3 billion euros. As EU member states are concerned, Spain is the top country who issues the number of fines by a long way. Spain issued 231 fines in 2021. In contrast, the UK issued 29 fines. When we're thinking about the value of the fine, Luxembourg far exceeds any other data protection authority, primarily because of the Amazon fine I mentioned. So it's important to bear in mind that if you, as an MGA and underwriting risks, if you have exposure in Spain or an incident in Spain, that may be more likely to be subject to an enforcement action or a penalty notice because the regulator there is particularly active. The Luxembourg authority may not issue as many fines, but it seems when they do so, the value of the fine is incredibly large. Both Luxembourg and the Irish DPC are both top in that regard, issuing tech companies a large number of a large value of fines. And then finally, I wanted to mention that from a litigation perspective, things continue to evolve from a UK and EU perspective. Briefly, the UK Supreme Court decision in Lloyd and Google resulted in a unanimous ruling in favor of Google, which prevented a large representative action to continue. We've all seen data breach claims run by plaintiff firms continue in the UK courts. And this has been has slowed down in recent times because of the Supreme Court decision. Similarly, in the EU Court of Justice has strengthened their regulatory enforcement by allowing member states and supervisory authorities to sue private companies under the GDPR. But we continue to monitor this, not least because late last year, the Advocate General of the EU courts issued a number of questions and an opinion in a case involving the Austrian Post, which was found to have the Austrian postal system was found to have infringed GDPR requirements, and they said whether or not you suffer material or non-material damage, that does not automatically constitute a right for you to issue proceedings against the organization. So that's the brief overview of the landscape in the EU, as well as the litigation landscape in the UK and the EU. I'd like to talk now about the ICO fines recently issued. Next slide, please, Gareth. There are 4 fines that were issued in the last year, and I just wanted to touch on them briefly. I'll speak about Interserve and Tuckers collectively because these 2 organizations were fined despite being victims of a ransomware attack. Now, typically, when we deal with the ICO, we indicate that an organization being a victim of a ransomware attack could not have done much more than they already could in the face of being an unsuspecting victim. However, these 2 fines serve to highlight that notwithstanding the fact that an organization may be a victim, the ICO will still look to key factors as to whether the GDPR obligations were complied with. In the case of Interserve, they suffered a ransomware attack, and as a result of that, the data relating to over 113,000 employees were compromised. They were issued a financial penalty notice of £4.4 million. And the ICO concluded that the reason they don't just look at the root cause of the incident, in this case, a ransomware attacker, is because that there were wider security controls that were not in place. And that led to them making a finding, against Interserve. So it demonstrates essentially that the ICO will adopt a holistic approach in their investigations, especially with the new commissioner now in force. Similarly, with Tuckers, they were the subject of a ransomware attack in 2020, and its IT system became unavailable. The ICO acknowledged that they were a victim of an attack, but then also concluded that Tuckers failed to implement appropriate technical and organizational measures. As a result, almost 1 million individual files, court bundles, and information relating to a piece of litigation by the law firm was made public. So an administrative fine of £98,000 was issued. So these 2 fines serve to highlight that notwithstanding you're a victim of an attack, it's really important to ensure that there is appropriate security and technical measures in place and ensure GDPR compliance in that regard. And finally, I wanted to address Clearview and Easy Life. These are both fines that were issued in May 2022 and October 2022 by the ICO respectively. Both these organizations collect data of individuals. In the case of Clearview, it was images of people's faces from the web and social media. They would collect these images and they had no lawful reason for collecting this information. And they failed to meet the higher standards required for processing biometric data. And as a result, the ICO issued a fine of 7.5 million. But it's worth noting that this fine of 7.5 million was a significant reduction to the 17 million fine originally announced in its provisional decision. And the ICO, in addition to the fine, also issued an enforcement notice ordering Clearview to stop collecting data of UK residents and to delete them from its systems. So we see a focus on the ICO taking a tough stance with respect to the collection of data, particularly biometric data, and the use of AI technology, as was used by Clearview to collect this data in this instance. Similarly, with Easy Life, there was collection of customer data to predict their medical conditions so they could be targeted with health-related products without their consent. And this is particularly significant because the ICO treats data that is considered special category data, in this case medical information, in different regard and holds it to a higher standard. And that was the basis on which the 1.3 million pound fine was issued. Against that backdrop, what does this mean for organizations moving forward? What will the ICO look like as we move into 2023? I'll hand over to Helen so she can give an overview on what we might expect in the coming year. Over to you, Helen.
Thanks, Rose. If we can move on to the next slide, thank you very much. So yes, as Rose mentioned, we thought that it would be beneficial to try and draw out some of the themes that we are likely to be seeing from a regulatory perspective over the next year or so. There is a lot going on. We have a new commissioner, so John Edwards, the new commissioner. He hasn't been in the post very long. He's obviously going to bring his own influence and ideas as to how the ICO will evolve and operate in the future. And he's already been quite clear and quite vocal in terms of what his focus is likely to be over the coming months. In terms of some of the headline points, as you see on the slide there, in terms of fine income retention, it was announced back in June last year that the ICO is now able to retain some of the funds that are paid as a result of its civil monetary penalties. Previously, all the income from these fines was passed to the government's central consolidated fund, but from this year, the ICO will be able to keep some funds to cover pre-agreed and specific litigation costs. It's hard to tell really whether that's going to generate any real change in behaviours. I mean, we've seen from the Spanish regulator that that always retained the fines. That seemed to generate a lot of enforcement activity, but here the amount is capped. I think it's £7.5 million, which doesn't seem very significant when you consider the potential scale of the enforcement action that it may be taking. But nonetheless, it is a change, so it will be one to watch in the future. The ICO strategy itself was published back in June 22, which set out the strategic vision of the regulator. Its main focus is really to empower people through information, but it sets out four rather key objectives. The first is to safeguard and empower people by upholding information rights whilst contributing to a sustainable economy. So from a practical perspective, it's aiming to help people understand their rights, to reinforce that knowledge, and to continue to tackle predatory marketing, things like that, driving some transparency when they're exercising discretion, issues like that. So in addition, we've got the other objectives of empowering responsible innovation, sustainable economic growth, to promote openness and transparency and accountability for the ICO as a regulator, whilst also developing its culture, capability and capacity. So a very ambitious strategic plan, but we're already seeing evidence of how it's trying to fulfill those objectives. So by way of example, in terms of empowering, the empowering objective, the ICO has developed a DSAR tool, so a data subject access request tool that is designed to help people make requests in ways that will help organisations respond effectively. For some organisations, it's an incredibly burdensome obligation to search for and identify the data that is subject to these requests. So hopefully this tool will help people identify where to send their requests and explain what they should expect by way of a response. And the receiving organisation will also receive information from the ICO to assist them in understanding how they need to respond quickly and simply. So that's just one area that we've seen a development. From an engagement perspective, the ICO is going to be embarking on some community outreach initiatives. So it intends to reach out to those communities and vulnerable groups that it hasn't previously engaged with. So, for example, partnering with special interest and representative groups to identify issues that are affecting them and in order for them to act on that information and feedback that they're getting. Another area of focus is also the safeguarding of vulnerable groups. I'll come on to the focus on children's data in a minute, but this is likely to include, this particular initiative is likely to include a focus on children's privacy, pressing for further changes by social media platforms, video and music streaming sites, that sort of thing. So as I mentioned a moment ago, we are expecting there to be quite a significant focus on the management of children's data. This is clearly an issue that the regulator feels very strongly about. The Children's Code was introduced back in September 21, but it has been very much a focus of the regulator over the past year. The code itself has inspired reviews of child privacy protections in California, Europe, Canada and Australia, and the regulator has already publicly encouraged the introduction of the Children's Code in other countries, as he considers that any further protections that are implemented in other countries will impact the safety of children here in the UK. So in doing so, I think we can expect the ICO will engage with companies who would fall within the scope of the code to build relationships with regulators, but also with lawmakers in other jurisdictions. I think by way of evidence of the focus on this area, the ICO, as you may be aware, issued the TikTok with a notice of intent back in September 22. That was for a £27 million fine due to a failure to protect children's privacy. The ICO considered that TikTok was in breach of the UK Data Protection Act between May 18 and 2020. The specific breaches included issues like processing data of children, processing data of children under the age of 13 without parental consent, failing to provide proper information to its users in a concise and transparent way, and a further breach of processing special categories of data without the legal grounds to do so. So that's just indicative of the focus that it's going to have, but also the regulator has confirmed that the ICO is in the process of looking at how over 50 different online services are conforming with the Children's Code, and they have 6 ongoing investigations that are looking into companies that are providing digital services who haven't conformed. So the investigations and any appeals are likely to carry forward to next year. It's all going on here. So going forward, focus is likely to be on social media platforms, video and music streaming sites and gaming platforms to assess children's ages, conforming with guidelines about profiling children and the sharing of data. And they're clearly going to push for improved transparency and the use of privacy notices, so there's much closer alignment with the online safety bill. Another area of focus that they have actually been enforcing for some time is the issue of predatory marketing calls. There's a new direct marketing guidance that's been issued, so there is a very robust protocol around this. Back in June last year, they issued the proposal to increase fines under PECA from $500,000 to 4% of global turnover. So there's been a lot of enforcement activity around this. As Rose mentioned earlier, the Easy Life fine for 1.4 million, that was really around the use of personal information of a large number of customers to predict medical conditions and target them with health-related products without their consent. So that was the central issue there. And in March last year, the ICO had announced almost £500,000 of fines to 5 companies responsible for 750,000 unwanted marketing calls that were targeting older, vulnerable people. So that's one area of focus. Another area will be around biometric technologies. The regulator is very alive to the fact that this type of biometric technology is becoming much more accessible in terms of a broader range of applications, and it wants to focus organisations' views on their need rather to be alert to the risks associated with the development and application of these technologies, especially around emotion and facial recognition technology. And one example of that focus is back in February last year, the ICO reprimanded the Scottish Government over the use of people's information in NHS Scotland COVID status applications, which initially included a proposal to help improve the facial recognition software behind the NHS Scotland COVID status application by sharing the images and passport details of Scottish users with the software company that was providing the facial recognition technology behind the app. So the proposal hadn't been communicated to the ICO, and it considered that the proposal would have been unlawful in those circumstances, as the circumstances surrounding the collection of data, the facial recognition technology was not necessary for the app to function, and it served no benefit to the app user. Along the same lines as Rose has just mentioned, ICO fined Clearview AI for collecting pictures from the web and social media to create an online database. So that was done despite the fact that Clearview no longer offered its services to UK organisations, but because the ICO was of the view that the company is still using personal data of UK residents. That was one of the rationales for the fine. In terms of other themes worth picking up on, from AdTech, AdTech was a focus of the ICO from 2019 to 2021, but the ICO as a regulator continues to focus to get AdTech regulatory solutions to really balance the privacy wins, such as the Apple's ad tracking transparency and Google's third-party cookie retirement. Those sorts of wins. Back in April last year, Google announced it was giving customers more choice and control over how the data is tracked, and that was welcomed by the ICO. They published a statement last year to say that it was welcoming Google's revised approach to cookie consent, that it was a change that it had been seeking through its ongoing discussions with Google and the broader ad tech work that was going on. So really it was welcoming the fact that consumers were getting greater control and balance of choice over the tracking of their online activity. So that's an area that I suspect we will see develop over the coming months and years. In terms of cookies, of course, it was a big topic last year with the French DPA issuing very large fines to the big tech companies such as Google and Facebook and Amazon. That was the CNIL in France, but no specific enforcement action has been taken by the ICO, as far as I'm aware, from 2022 on cookies. But the government's response to the data consultation confirms that there will be further reforms to PECA, such as the government moving to an opt-out model for cookies, but that's only really going to be possible once the website technology is able to give users control over cookies across the website. So that's something that perhaps we will see more robust regulation around in the future. Looking ahead in terms of 2023, in November last year, John Edwards noted that he had significantly reduced a fine to the Cabinet Office from £500,000 to 50,000, which was really indicative of the ICO's changed approach to monetary penalties in the public sector, taking into consideration the economic and fiscal crisis. So going forward, he has made it clear that he's going to use his public discretion to reduce the impact of fines in the public sector, with the emphasis more on supporting and encouraging compliance before harm arises. So we can expect that fines will remain an important regulatory tool. The ICO will use them, particularly in instances where they feel that they are truly needed, but really they will be aimed at the breaches which are causing or have the potential to cause the most harm to people, or where a business, for example, has profited from its non-compliance. So it's going to be a much more nuanced approach, bearing in mind those public statements. It's going to publish reprimands. The ICO will publish and has started publishing all reprimands going forward, including any that were issued from January 22 onwards, unless there is a good reason not to. In terms of the rationale for that, the ICO is clearly looking at accountability, wanting the rest of the economy to know what's happened and the reason for the infringement, probably to act as a deterrent as much as anything, but to demonstrate that the ICO really does the actions and the priorities that it has and the actions that it intends to take. So some of this is about giving organisations the certainty as much as it can in what the law requires from them. We are expecting that to have an impact from a litigation landscape perspective. This is clearly going to be material that hasn't previously always been available to, in particular, the claimant law firms that will be looking to build their claimant populations in terms of bringing litigation. So it is very much watch this space in terms of what we see going to happen. So that's probably it in terms of the horizon scanning from an ICO perspective. If we move on to the next slide. Rose, I think you're picking up on this.
Great. I mentioned earlier at the start of the presentation that the UK GDPR now exists independent of the EU GDPR. And whilst for the most part, substantively, they basically mirror each other, we're beginning to see it diverge. And the reason for this is the UK Data Protection and Digital Information Bill that is currently being considered by Parliament. And if this bill comes into force, it will present a step change in the GDPR regime as we know it. By way of background, the origins of this bill is a government consultation which considered how we wanted to deal with data in the UK. There were 5 objectives in implementing new data protection legislation, and the bill was introduced in Parliament in July 2022. The main motivations for bringing about this bill was that the UK government is keen on removing these barriers placed on businesses to adhere to data protection obligations and wanted to lighten the burdens on them currently placed on businesses and consumers. The intention is that this bill will move away from box ticking that is currently perceived in the GDPR, and they wish to lighten the burdens, as I mentioned, as businesses in the UK processes data in both the UK and in the EU. The issue is there's been very little information forthcoming as to how the bill will now be developed. The new Secretary of State for Digital Culture, Media and Sport did say that this new bill will be for our own businesses and consumer-friendly British data protection system, observing that the GDPR is a one-size-fits-all approach. So there's this clear intention to reform the GDPR and to simplify things. Based on what we've seen in the bill, much of the draft text is in keeping with the current status quo, but some of the changes we're expecting to see is summarized under the first bullet point there. Firstly, there are changes to the accountability framework. which includes alternatives to the requirements to undertake a data impact assessment, frequently known as a DPIA, and to appoint a data protection officer. Under the new legislation, it removes several requirements, including the requirement to undertake the DPIA or for organizations to appoint a data officer, and for the requirement that controllers and processors maintain a record of processing activities. What does this mean for you and your insureds? One thing to consider is whether in submissions or proposal forms, are there existing requirements that insureds have a data protection officer, carry out a DPIA? And the reason this is worth considering is if the bill comes into force and there is no longer a legal requirement to take these steps, and these requirements are replaced with flexible and less stringent alternatives from insurance perspective, would you as an MGA, or should insurers wish to reflect the legislation at that point in time? Or from a practical perspective, will you still require your insureds to still undertake DPIAs, because that will necessarily translate in more robust security and compliance from a data protection perspective? So that's how we think an instance of how the bill might change things, not only legally, but in the way you might do business. Helen mentioned that data subject access requests might change, not least because the ICO is introducing a tool that will be on their website to make it more streamlined and straightforward. The current bill is amending the threshold for charging data subjects a reasonable fee. And so it previously, when it was the test applied under the GDPR for an organization to refuse a DSAR, was if it was manifestly unfounded and excessive. Now it's being changed to vexatious and excessive. So as there is now a change in the threshold, there is a fresh assessment that an organization must undertake before it considers a DSAR to be vexatious and refuses to do so. So changes such as that is also another instance of how the bill might change the data protection landscape. There are also efforts to ensure that the transfer of data between countries, the UK and other countries, are improved. Basically, there's an effort to boost trade and reduce barriers to data flows. The requirement for assessing adequacy, which is a concept ascribed that ensures that the UK may only transfer data to a third country where they have an adequate data protection regime in place equal to, so that the rights of residents or those residing in the UK are not compromised if an organization sends data outside the country. Now, the bill proposes that the test on whether you can send data out of the country is now going to be focused on a risk-based decision-making test. And this test will be met if the standard of data protection in a third country is, quote unquote, not materially lower. So that is a different test than requiring an adequacy arrangement or bilateral arrangement to be in place between the UK and another country. There are also other alternative transfer mechanisms. Some of these concepts were explored in the Schrems 2 case, which some of you might be familiar with. But the essence is that following the reform of the bill, the use of an alternative transfer mechanism ensures that there must be appropriate safeguards, but these safeguards are now to be determined by reference to the data protection test and what is considered to be reasonable and proportionate. So it's an expanded test and no longer requires strict bilateral arrangements or standard contractual clauses as we might be used to under the Schrems. Helen mentioned that the ICO with John Edwards as a new commissioner is moving things in a different direction, and the data protection bill, once in force, will also put into place structural reforms for the ICO. The new legislation essentially provides a new principal objective for the ICO to ensure that they take a proportionate risk-based approach to its regulatory activities. And there are a basis on which it should handle complaints, which is meant to align it with other regulatory departments such as Ofcom, and under the legislation, the ICO is, it's also being considered that ICO is capped at imposing financial penalties of up to £500,000. This will be incredibly interesting to see if this follows through. Will financial penalties then be capped at £500,000 with respect to breaches under the PECR specifically? So those are some of the interesting developments and changes currently proposed in the bill, and we await what the current state is and how it will continue to develop over the months. As I've mentioned, it's currently before Parliament, but given the change in government and their varying focus on the economy and other pressing matters, this has taken a backseat at the moment. And as mentioned in the second bullet point, we're expecting to hear an update soon, and we expect that discussions on this bill will begin shortly, but no doubt we will update the market as soon as that develops further. Finally, I just wanted to flag the NIS regulations. The NIS regulations is short for the National and Information Systems. This is currently already in force, but the UK government is looking at refreshing this. It's particularly significant for NIS regulations if you have insureds that are considered to be operators of essential services or digital service providers. The new NIS regulations expands the scope of the legislation to not only catch your operators of essential services, such as an electricity supplier or water supplier, but now to manage service providers. So what that means is that in addition to the obligations under the GDPR, and in the event of a ransomware attack of any such breach, they're not only reporting obligations under the GDPR, but if you have an organization that is considered to be an MSP or an operational operator of essential services, the NIS regulations might apply. And under the NIS regulations, a notification must be made within 24 hours. So for those of you that think that the GDPR requires a stringent notification requirement within 72 hours, the NIS in contrast will require one in 24 hours. This increased scope of the NIS that we are expecting to see is significant because MSPs or managed service providers are not currently defined. So the exact scope of what type of organizations which will fall under MSPs is not entirely clear. Now, the government has provided some sort of framework as to what might be considered MSPs. So we urge you to look at that definition, which would encompass any service management provider who provides IT networks or IT systems. They will then fall part of this framework and have additional legal obligations. And in contrast to the NIS regulations that are currently still under review from a UK perspective, I just wanted to note that the NIS regulations have actually come into force from a European context in the EU. So that came into force on 16 January, just 2 days ago, alongside the DORA, or the Digital Operational Resilience Act. So what we're seeing here in the UK is, while we're still contemplating the data protection bill, which I just mentioned, and the NIS regulations, in contrast, in the EU, we've seen two different legislation fall under the Digital Operational Resilience Act, DORA, and their version of the NIS regulations coming into force just 2 days ago. With DORA, I should just mention that to the extent that there are any EU organizations, now that the legislation has come into force, they just have 2 years to ensure that they comply with this new regulatory framework. And the DORA in particular will apply to financial entities. And so to the extent that organization and insureds fall under the banner of financial institutions or financial entities, there is yet another framework that they must comply with different obligations. And whilst that is strictly, as I mentioned, an EU development, much like the NIS regulations into the EU coming into force, it is nonetheless worth noting because, as we all know, data protection is jurisdictionally agnostic, and cyber attacks can affect companies, customers, and individuals across borders. On that note, I might hand over back to Helen, who can give you the answer how we can resolve all of this. Over to you, Helen.
Thanks. I don't know, there is a question in terms of the DPIA. Do you want to pick that up, Rose, or do you want to come back to that? Do you want to think about that and then come back to it at the end?
Yes, sure, of course.
Because I think that the actual answer to that is there's quite a prescribed list of circumstances when an organisation would have to undertake a DPIA, but we can give you an overview of essentially it's when it amounts to a high risk, to a processing activity that amounts to a high risk, but there are a number of circumstances that are prescribed. So I'll let Rose think about that and we can come back to that at the end. So if we spend the next few minutes that we have left, I'll try and leave us 5 minutes at the end for questions. In this next section of the presentation, if we move on to the next slide, if that's okay, Gareth. Thank you. We just wanted to pick up on some guidance on how you can assist your policyholders in preparing their organisations for cyber incidents and the type of considerations that are worth thinking about in advance. You'll see there in terms of a slide in terms of the Clyde & Co global cyber practice, which we have called ONE, and I'm using this as a reference tool really to demonstrate how with some pre-planning around the cyber readiness, you can really mitigate the exposures that organisations feel when cyber incidents happen. And it's quite clear that organisations are going to face these types of threats and potential regulatory scrutiny for some time to come. So we just wanted to highlight some of the issues that in our experience of handling the larger cyber incidents, it may be worth considering by way of forward planning in advance of the cyber incident actually occurring. So as a firm, we've structured it on the basis we've adopted the 3 limbs of readiness, response and recover. That's our way of approaching the management of the cyber risks and breach incidents, and it's a good way of capturing that life cycle of most issues that are likely to arise. And as I said, hopefully it will be a useful reference point for you to assist in discussions with policyholders. If we go on to the next slide, that's some of the features. So in terms of structuring the appropriate support for organisations dealing with a cyber incident, we've factored in that many companies have a broad geographical footprint. Dealing with an incident can place a significant burden on the management team, particularly where there's a need to manage the impact across several jurisdictions at the same time. So it's absolutely key that the appropriate communication channels and access to the right expertise is available to achieve the best outcome. So communication channels and protocols are just one of the key considerations that ought to form part of that cyber planning process. The incidents themselves, of course, can arise at any time. So it's critical that the support structure is available and accessible 24 hours a day, 7 days a week. A significant proportion of the incidents that we handle arise outside of business hours, so ensuring access to expertise at weekends is really important. It's also key that organisations implement a response protocol that is relevant to the particular needs of an organisation. Quite often this doesn't happen. And many of the clients that we come across really haven't done that bespoke planning process that would really set them up for success when an incident actually happens. So that really needs to take into consideration the structures of the organisation, geographical footprint, in particular the location of key digital assets and systems. So that data mapping piece is really important before an incident happens, but also it's the practical steps like identifying key stakeholders that need to be involved in the decisions that arise from cyber incidents, making sure people are contactable, and making sure that people understand the decision-making processes that need to be mobilised in order to manage an incident. Whatever the methodology is required, this really does need to be tested against various scenarios. So a business interruption event or a breach of data, for example. There are other issues that need to be grappled with as well, such as deciding as an organisation whether or not it would consider paying a ransom demand and the implications of that. It's much better if these issues and subjects are dealt with as part of the pre-planning phases of managing an incident rather than when you're in the moment and it's a business critical decision. So whatever support structures are put in place, it's key that the organisation has access to specialist knowledge of regulatory implications. Beyond the UK and the European regulatory landscape that we've touched on today, over the last few years, we've seen a large number of jurisdictions implement regulatory regimes for data protection that require notification of breaches to regulators by way of example, Brazil and South Africa, Australia and New Zealand have quite a mature notification regime. So it's important that organisations have efficient and timely access to that regulatory advice so that they are in a position to meet those regulatory obligations. As part of an organisation's general cyber planning, we would also strongly advise them to meet the breach coach or incident response team, to nominate them ahead of any incident happening. We offer meet the breach coach sessions to our clients, and they're always hugely beneficial. It enables us as an incident response team to familiar ourselves with the organisation and vice versa, and if necessary, educate the organisation on the roles that each member of an incident team need to play to support that response process. It's also an opportunity to consider the type of vendors, the third-party vendors, so IT, forensics, payment providers, those vendors that would be suitable for the company to appoint, depending upon the nature of the incident. So the familiarisation process always improves the overall outcome if and when an incident occurs, and as I said, we offer that opportunity, and it does offer an advantage to clients that take us up on it. Companies can select different IT vendors depending upon whether they're experiencing small business email compromise compared to a large scale ransomware incident. So all of these things, issues like that, can be discussed well in advance. It's also a good opportunity to share a current view on the latest issues and threats that an organisation may be facing. Very quickly, if we move on to the next slide, and the next one after that, I've probably covered most of that. So as I said, we've structured it around readiness, the 3 pillars of readiness, response, recover. Readiness, as I've already touched on, it's all about the preparation and thinking ahead, getting the protocol ready, potentially selecting preferred vendors ahead of time. Overall, it really is just common sense planning, but done in a timely way. It really does offer an advantage. Cyber simulation exercises is something that could be considered. They're an opportunity to really stress test those plans that I've just mentioned to address any obvious vulnerabilities that may exist. We offer a full range of incidents that are based on our own real life examples of managing incidents, and hopefully there's always something to be learnt from that, and it always prompts an organisation to reflect and review its plan. Other factors that may be worth considering, encouraging an organisation to conduct a data mapping audit to consider what data is held, where it's held, and what the data retention policy is. Is it a compliant data retention policy? We've dealt with a lot of incidents that involve legacy system data. That's something that is often forgotten, particularly if a company has undertaken a lot of merger activity. The legacy data is often quite problematic because it isn't really visible, and people don't always know why it's actually been retained. So another aspect that's worth considering is the supply chain assessment, particularly where there's a digital connection between an insured or policyholder and a vendor or supplier that may mean that they face that increased risk of exposure to an attack. So reviewing those cybersecurity standards that are expected of suppliers is another good idea. We'd also recommend a third-party contract review, that this is undertaken and audited and stored somewhere that is accessible in the event of an incident. In particular, noting where commercial parties may need to be notified following an incident. Again, there's been a lot of incidents that we've handled where organisations know that they are obliged to contact clients, but they don't know which clients, and they don't know when they need to do that. So again, a bit of pre-planning can improve the overall outcome. If we move on to response very quickly, this is probably more straightforward. This is really just about identifying what needs to be done when managing an incident and when. The detail of the response protocol is absolutely key to effectively managing an incident. So the more an organisation invests in that ahead of time, the better. And it's key to ensure that you have a means of gathering an organisation's internal stakeholders together with external advisors in the most effective and timely way. As I've already mentioned, it needs to be 24/7 access. You need to have that to get hold of your incident response services. You need to have access to a comprehensive panel of vendors to cover that full range of disciplines. So that extends from the forensic IT providers to payment providers. Dark web monitoring is also a useful resource in some cases, as well as the credit monitoring and notification services. Data mining specialists may be required if a large amount of data has been compromised and needs to be analysed for regulatory and legal purposes. So there is an enormous value in having that panel set up in advance. Many cyber incidents obviously carry significant legal implications, and in our experience, any significant event involves mobilising advisors in multiple jurisdictions within very tight timescales. So the more that an organisation does pre-incident in mapping where those demands and needs may be, the better. We're running very short of time, so if we can move on to, I've set out on the next slide a typical incident response protocol that we'll obviously circulate these slides afterwards, and that is a sort of a good overview in terms of how we structure incidents, how we make sure that all of those communication and reporting channels are set up appropriately. If we move on to the next one, I think I've already touched on a vendor management. There's a lot of change in the vendor space. We manage our own panel internally, and it's a very dynamic panel. There's a lot of merger activity. So the key thing is that you can establish horses for courses, in the sense that you can scale the vendor services according to the incident. Not every incident requires that multinational vendor approach. So we tier ours according to whether it's a domestic incident which may only require a small boutique firm, right up to the global multinational incidents that we handle. We can move on, thank you. So recovery, this is really the end game, to get the business back to business as usual as quickly as possible. In anticipation of that, we assist with the regulatory investigations and challenges that may come the organisation's way. As we've already alluded to, there's been a lot of third-party claims litigation following cyber incidents, as I'm sure many of you are aware. Rose mentioned some of the class actions that we've seen. In terms of a good news story, we've seen a lot of pushback for some of those more attritional data breach claims that we were seeing a lot of a couple of years ago. I think the courts, particularly in England, have shown an appetite to really address that and achieve a level of proportionality. So that won't deter everybody, but I think in terms of the trajectory, we've seen that from a defence perspective. There have been some positive developments that will limit some of those exposures going forwards. I realise I'm almost on the hour, so if we move on to the next slide. This is just one of the benefits that we offer. It's the cyber source, which is available to our clients. There's, as I'm sure you're aware, there is a huge amount of data and knowledge that is available in respect of cyber. It's a very dynamic landscape. So we've pulled all of our knowledge management piece together from a cyber perspective into one coherent place. So we've called it Cyber Source, and hopefully, as you see there, we've put it against the readiness, response, recover themes. So that's really as a support tool to clients to understand the latest threats and issues that they're likely to be managing, and some of the legal issues and regulatory developments. I think if we move to questions, if you move on one more slide, that's just some information on how we manage management information and look at portfolio data. So on that note, Rose, shall I come back to you to give a more detailed answer on the DPIA question whilst we wait for other questions to come in?
Sure, I'll just give a 30-second answer briefly, given the time restraints. So basically, a DPIA, as Helen mentioned, is required if it is likely that your insured is processing data that is quote unquote likely to result in a high risk. Now, the UK GDPR currently says that regardless of this assessment, you must do a DPI, meaning it's mandatory if your insured either A, uses a systematic and extensive profiling with significant effects. So the Clearview example is a great one. They systematically use AI to profile photos and scrape them from the web. If you have additionally, or in the alternative, if you process special category or criminal offense data on a large scale, and that's the Easy Life example I mentioned earlier. You'll recall they were processing medical information data to subject that organize the individuals with targeted ads. Another factor is if you systematically monitor publicly accessible places on a large scale. So these are the mandatory requirements. And the ICO website also lists out various factors that you may wish to consider. And this range from if your organization or insured uses innovative technology. Helen mentioned the use of AI, cookies, ad tech. Those are all the areas of focus. If you process genetic data, biometric data, I've mentioned that with Clearview, and continue to use special category data. So it's the areas of sensitive data using technology that allows you to sweep information in large scale or use children's data track location. If you fall into any of those categories, then your insured must conduct a DPIA under the UK GDPR, but that remains to be seen depending on how the UK data protection bill pans out.
Great, thanks, Rose, and thank you, Helen. We're out of time, unfortunately, but if you do have any questions, any further questions, do feel free to read them through to Helen or Rose. You can see their details there on screen, or indeed send through to me and I can pass them on. So my email address is tim.richards@mgaa.co.uk. So yeah, thank you very much, Helen and Rose, for your presentation today, which I'm sure everyone will agree has been fascinating and extremely useful. So thank you to you both. Thanks to everyone for joining us as well. Please don't forget to provide your feedback and do look out for forthcoming MGAA events. So it just remains for me to say, I do hope you have a productive afternoon. Thanks again for joining us and see you all soon.